Circumstances under which government can be sued.
Yes, welcome to today's class. My name is Mordecai, and I'm going to take you through what we call vicarious liability. And vicarious liability is defined as a legal principle in which a person is held liable for another person's conduct. Have you ever asked yourself whether in any circumstances government can be sued? The government can only be sued through a process called vicarious liability. So, what are the circumstances in which a government can be sued? In an ordinary case, government is usually sued through a breach of contract, because we realized that government was initially not liable to be sued. But because government had become an employer, government had reached a time and it had entered into contracts with individuals, different kinds of contracts. So we saw a need to regulate the activities of government. And here today we are looking at the various ways in which one can bring up action against the government in the courts of law. Number one, we say that governments can be sued through contracts, but these contracts have to be in line with the law. If you have a contract with government that is not in line with the law, then that contract, you cannot sue under that kind of contract. This is stipulated under Section 2 of the Government Proceeding Act. The Government Proceeding Act stipulates the kinds of contracts that the government must have with people, and we say that such contracts must be in accordance with the law, and if they are business contracts, they must be in relationship with, if they are commercial contracts, they must be in line with the Public Procurement and Disposal of Assets Act, which clearly defines what a business contract or a commercial contract may be with government. So here we have case law, we have decided cases that stipulate this position. If you read the case of Fishing Torch Uganda Limited versus Attorney General, and the case of Clear Channel Independent versus PPDM miscellaneous application, you notice that there was a position that in order for one to enter into a contract, a procurement contract or a commercial contract with government, it must be in line with the Public Procurement and Disposal of Assets Act. Then, secondly, contracts with government that can be actionable before court must be in line with the procedures, with the right procedures. If it is an employment contract, it must be with the Public Service Act or the Public Service Standing Orders of government. If it is not in conformity with the Public Service Act or the Public Service Standing Orders, then you do not have a contract. So in this act, it is well stipulated that one must be lawfully appointed in order to have a contract. Maybe it is an employment contract. You must be lawfully appointed in order to contract. If you have not been lawfully appointed by a lawful personnel who is entrusted by government through an act to carry out such an appointment, then you are not an employee of government. We have case law of a Mr. Wycliffe Chigundu versus Attorney General. Okay, Mr. Wycliffe Chigundu was appointed to serve without a contract, so that means that he was not rightfully appointed to serve, and he claimed to have a contract with government. And the position of court was that there was no valid contract and he was not an employee of government. Lastly, for one to have a contract with government in which he can sue in breach of contract, because government also breaches contracts, that contract must have been based on the standard terms and conditions of government that are not negotiable. Government has standard terms and conditions that are not negotiable. For example, I would give a case in Charles Rwamushana versus Attorney General. Charles Rwamushana was serving as an executive director of ISO, an intelligence organization that most of you know. And when his term of contract expired, he was appointed as an RDC somewhere, but he wanted to retain his salary of 9 million shillings from which he had been receiving as an executive director of ISO. He wanted to retain his salary as an RDC. And the position of court was that government has standard terms and conditions that are not negotiable. If you have been an intelligence officer under ISO and you have been receiving a particular salary, that salary stops there and you cannot carry it on to the office of a resident district commissioner. Then secondly, away from contract and breach of contract, government can also be sued under what we call tortious liability. A tort is a civil wrong. Government can commit civil wrong. Okay? So, what circumstances can government be held under a tort? We defined vicarious liability, that government commits torts through vicarious liability. And vicarious liability is defined in the case of Okupa versus Attorney General. Vicarious liability was defined as a legal principle in which a person is held liable for another person's offense. Okay, many of you have been asking yourself that, can I sue a police officer that comes to my home and arrests me without an offense? Can I sue that police officer? This is where you can sue. You can sue government for that. Okay, so that police officer commits a tort, but you have a right to sue government because that police officer is an employee of government. So under what circumstances may an employee of government's offenses be held on government? We have a case in a Ketch Laws versus Attorney General. We are told that the tort committed by a police officer or an ordinary employee of government must be committed when that officer or an employee is in ordinary course of employment of government. This simply means that if a police officer commits an offense, he must be in an ordinary course of his duty as an employee. That means he must have been deployed by government. But if he is doing it personally with his own emotions, with his own thinking, then you cannot hold government liable for his offense. You have to take him on as an individual and not as government. So the case of a Ketch Laws versus Attorney General explains this well, that in order for government to be liable for the actions of their employees, those employees must be in their ordinary course of employment. That makes government liable. So this brings us through the principle that he who acts through another acts himself. That principle is termed in a Latin maxim called quic facit per se, facit per alium. Okay, so who can be an employee of government? One, we have two kinds of employment. One, an employee for service, an employee for service, an employee of service, and employee for service. So for one to be an employee of government that makes government liable, that employee has to be an employee for service. That means that person is not under a short-term government employment deal. For example, if I am employed to go, I have a construction industry or a construction company, then I am employed by government to go and repair the Ministry of Public Service building. Then as I am in line of repairing the building, a brick falls down and hits someone who has come to receive services from the ministry. You cannot hold the government liable because I am an employee of service, not for service. So you have to sue my company, not government. You have to sue my construction company, not government. Therefore, I am an employee of service. You get? But an employee for service is someone who is a permanent employer for government. Okay? So, we continue. So, when you are suing government, you have to sue the Attorney General. You get the point. In the case of John Patrick Amama Mbabazi, a presidential election petition number 1 of 2016, we were told that when there is a presidential election petition, one has to sue government. One has to put government among the respondents, the Attorney General among the respondents. But we are told in the case of Kabandize versus KCCA and Attorney General that in order for one to sue the Attorney General, you must give him a 45 days notice before you bring an action against him. But remember, the presidential elections petition is given only a few days before the actions are made. I think that brings us to an exception, okay, to that general rule. Then the next case we can look at is that there is a case of Dr. Sylvester Ozevua versus Attorney General. To many of you who remember the case of the Honorable Nebanda. Okay? In this case, we are told that for actions to be brought against government, they must not be time-barred. So Dr. Sylvester Ozevua had brought action against the Attorney General after a period of 2 years, and we were told that he had been his suit was time-barred, and therefore the Limitations Act would not allow such a suit to continue. So what are some of the defenses that the Attorney General might have in case you have brought up such such actions against the state? 1. Defenses of Attorney General. We have immunity or privilege. Okay? We are told that the government has particular immunities that you cannot action against them. 1 is judicial immunity. 2nd is diplomatic immunity. Okay? The other is the act of state doctrine. Okay? Under immunities, we have a case of Gladys Nachibule, Attorney General versus Gladys Nachibule, Constitutional Appeal number 22. And Nachibule was charged for professional misconduct before the courts of law. And she was claiming to have professional immunity. But court held that professional immunity is only to personal liability and not professional liability. Next is immunity of public officers under Article 173 of the Constitution. If a public officer does anything in good faith, then it is codified. You get the point that if an officer arrests you suspecting you to be a thief and you are brought before the courts of law, you cannot bring action against them because their actions are codified. That is, if the arrest has been done in good faith and not malicious. However, if it is malicious, then you have to sue them for malicious prosecution. Nobody has a right to arrest you innocently. We have cases, for example, David Kasirinji versus Makerere University, where the former was a cook and he was maliciously arrested and prosecuted for having on suspicion that he had stolen food items, yet he was not the one from the university stores. So he actioned for malicious prosecution and damages were awarded to Makerere University. Next we have the act of state doctrine as one of the defenses of government. Act of state, government has some decisions they make that seem unquestionable by public, and even court cannot intervene amongst them. For example, in the case of Crane Bank Uganda Limited versus DFCU of England and Wales Commercial Court, case of 2020, Asudil Ruparelia went to the United Kingdom in England and sued for the closure of Crane Bank, and he was told that you cannot sue because these are matters of state and you cannot sue them in a foreign country. You cannot ask such questions in a foreign country. Another question is, another case law is Senyendo versus Attorney General, where there's a question to do with armed forces suing government or for armed forces causing damages arising from war and so on. But you cannot ask questions to do with war-making powers and etc. before the courts of law, because you will be told that that is an act of state of which court is established into the state, and court cannot answer such questions. The next defense is political question. The courts usually have the government has a defense of political question doctrine. The political question doctrine is when individuals come to court seeking answers regarding policies of government. Some policies of government are unquestionable under what we call the political doctrine question. We have several cases here. We have the famous case of Uganda versus Commissioner of Prisons ex parte Matovu of 1967, where there were questions regarding the constitutionality of Obote's 1966 overthrow of Kabaka Mutesa's government and the rise of the suspension of the 1962 constitution, the rise of the 1966 constitution, and the subsequent Republican constitution of 1967. So, when Michael Matovu, the parish chief of Budu, went before court asking what is the legitimacy of the new government, what is the legitimacy of the new president, court told him that that is a political question, because if you ask for the legitimacy of a constitution that has been overthrown, using a new constitution to ask about the legitimacy of the previous constitution, you will not receive an answer from court, because by the mere fact that you are suing under a new constitution, it means you have already recognized it as the supreme law and as a law that is binding on you, so you cannot ask questions of the sort. So, more cases under political question. We have the case of Nampogo and Tumwesije versus Attorney General. Nampogo was demanding government, and she decided to attach a police vehicle. She grabbed a police vehicle and parked it in her compound while demanding government. She was told that it is a political doctrine question. Government property cannot be attached to your request. Another one is Hassan Basaja, Mr. Hassan Basaja Balawa versus Attorney General, where Hassan Basaja Balaba wanted to attach funds from the consolidated fund, and he was told that those funds are held by government in trust of the public and they are public funds, so you cannot attach them to your debts. Thank you very much. That has been my exhibition today in regards to vicarious liability and the conditions upon which government can be sued or held liable in breach of contract or in commission of tort or tortious liability. My name is Mordecai. See you next time. Thank you.